final oral argument today. The case is State versus Shekels. I'm going to have counsel introduce themselves to the court and to the audience. I'll start with you, Mr. Springman. Thank you. Ms. Peters? Thank you. Mr. Springman, whenever you're ready, you will have 15 minutes to argue this morning. Would you like to reserve any time in rebuttal?
Sure, Your Honor. Thank you. I would reserve 3 minutes.
All right, and I will keep your time whenever you're ready.
All right, thank you. May it please the court, Ms. Peters. This appeal, in short, boils down to it's the state's position that the trial court treated these motions in limine improperly and made definitive rulings excluding 2 items of evidence.
May I interrupt and stop you there? Because would you agree that normally a motion in limine is preliminary only and that any ruling needs to be waited until trial to see the facts and the circumstances when the evidence is offered?
That was my next sentence, is that's where I believe that the trial court made a mistake and it should have waited, given the state an opportunity at trial.
So what do we do with that, though? If it's preliminary only, are you saying it wasn't preliminary only in this case? Because if it was, it's not a final order, is it?
Right. We believe that that's a problem where the trial court did treat it. He did not treat it as a preliminary order as it should have been treated. So that's our issue, is that the trial judge should have treated the motion in limine as a motion in limine, made an anticipatory ruling, which could have been he's anticipating excluding the video evidence or anticipating that he's excluding our prosecutor from testifying.
So is your issue in the language of the ruling? And this is what
Okay.
because in actuality, we don't know what the judge would have done, right? Because we're here and,
We're here.
right? And an appeal was taken. So we don't know, like, if you had, if the state had tried to introduce the testimony or the video, or if something had changed, what the trial court would have done. We don't know that. All we know is the order that was written. So does it come down to the language of the order? Is that what your concern is?
Yes, and it's very clear from the context of the hearing, the judge was excluding both items of evidence. There's very clear the judge was not going to allow the state to introduce the testimony of Assistant Prosecutor Zach Kessler, nor was the judge going to allow the state at all to introduce the video.
Well, I was going to ask, how can we even review that determination because we don't have a copy of the Tilly letter that was proffered in any form or fashion that I've seen?
No, it was not proffered. It would have been better if it was proffered, but I do not think that would affect our argument that this motion in limine should have been an anticipatory ruling, and it clearly under the record was not. So whether the TUI letter was proffered or not, the judge clearly was not going to allow Attorney Kessler to testify.
It might have been futile, but this was a bench trial. Could you have started the bench trial, made your opening statements, called your first witness, and called the woman who was going to authenticate the video? Shouldn't that have been done and then force the court to make a true final ruling instead of a preliminary ruling? I know you're saying it really wasn't a preliminary ruling, but could you have tested that?
In a bench trial, that might have been something you could have done. You could have tested it, but it was very clear here. We were not going to be allowed to have Attorney Kessler nor that video introduced into evidence. It was.
I'm not sure that's a fair reading of the record because Judge Schritz was asking for the letter, and there was equivocal testimony or commentary during the colloquy report where someone says something like, "I think it's on my phone, Your Honor," and rather than having that individual at least read what's on his phone to let the court know that, hey, we've got this letter, or saying, let me send this to your honors clerk or something like that. Nothing was ever put forward to the judge to show that you guys actually had the letter and we're good to go.
Your Honor, that's a good point, but on page 20 of the transcript, I did highlight that our prosecutor, Mr. Leon, said, Your Honor, we can give you the telephone. They had it. And the judge was a little irritated and maybe rightly so, I don't know, but at the parties because he was getting these motions on the day that it was set for trial and, you know, that
It's in the statement. I have it on my phone, I think.
the statement I have is, at one point it was, but later they did have it. And on page 20, I find the statement to be rather clear, the record clear. Your Honor, we can give you the telephone, which meaning that's the letter was on the telephone. And so, and further, I'd like to state that Mr. Kessler told us, and here's the other issue. You know, TUI and whether or not,
Can I interrupt you and
Sure.
ask a question that's been on my mind about the
Yes.
TUI letter?
yes,
What basis does the court have to exclude evidence on the basis that there is no TUI letter? Isn't that just something that says, hey, if you testify, you're going to be in big trouble with us? I mean,
Yeah.
you could still call the witness to testify and the witness could choose to, I suppose, assert a privilege or not assert a privilege. It's not even,
Right.
on what evidentiary basis was it excluded?
well, that's another problem. That's an issue that the state had is, you know, this was, if it was motion in limine was treated as a motion to suppress, it wasn't suppressible because we're not talking about a constitutional issue. And on page 4 of the record and later, I think it's 20 and on, it was made very clear to the judge that, you know, once you look at 16 United States code that deals with TUI letters, our assistant prosecutor, Zach Kessler, was confident that that he could testify without facing any potential sanction under TUI anyway. So again, I'm not sure why.
But that goes back to then why not proceed with the trial, call him as a witness and let him testify?
That's what we think should have happened. And so the judge wasn't allowing that. And
Well, as I read the actual order, it says the motion eliminate to prevent Mr. Kessler from testifying is granted, which looks to me like, you know, any other motion eliminate ruling that is made before trial, just because it's granted doesn't mean you can't then move forward as Judge Myers is suggesting and test that and say like, well, now we're ready. He doesn't need the Cody letter. We're going to keep his testimony within this narrow realm or something like that.
yes, I think it's clear that the judge excluded this evidence and the state's case was destroyed. But yes, I don't know that. It just seems to me that would be disrespectful to just go ahead.
Well, it might be,
I know, yeah.
but I mean, motions in limine are preliminary only. If the judge is wrong about that, if the judge treats it as final, that's what I'm struggling with, that, as you can
Right.
tell.
And I am too, because there is, you know, the case law out there that not all motions in limine are alike. You know, the reason we were able to bring the appeal, at least we have some case law that does say that sometimes judges do treat motions in limine improperly as motions to suppress. And I think the judge did that improperly here. And so then again, our case was destroyed or ended, and we didn't go forward because it was made pretty clear to the state that it was done. It was over. We certainly
Same
were
with-
under the impression we
Isn't
could.
it also if the net effect of the motion to eliminate is as a motion to
Suppress.
suppress, then it's appealable.
It is.
So by you appealing it, you treated it as such, I think it could be argued that you treated it as if the letter was not producible.
No, I would say that if we were going to treat this as a motion to suppress, then the trial judge erred in suppressing the testimony of Mr. Petzler on a procedural issue and not a constitutional issue. And I would say the same thing with the video, motions to suppress deal with constitutional violations, not with procedural violations. So yes, I would go along with my argument. I think the trial judge improperly considered this as a motion to suppress. And in doing so, you can't suppress an issue that is not of constitutional import. The TUI letter involved a potential violation of,
What would be the language that you think would have been proper in both entries? 'Cause there's a little difference in each entry on the language.
right. I think that there should have been something in the entry that would indicate that this is a preliminary ruling, and then the state would revisit it at trial. And then it would have been clear to everyone that we could have gone forward, but
So
the,
saying motion to eliminate, you're saying is not sufficient because it's entitled entry granted motion to eliminate.
yeah, granted a motion to eliminate, and there's nothing to indicate that it was preliminary in nature. And you're right, it doesn't come through the record, but the judge was not going to let us go forward on this.
So you couldn't have attempted to authenticate the video and then have him say on the record, I already ruled on that, I'm not changing my mind. I understand why that would be difficult, but
Well, yes, I don't think that we could have done that, and I would further also maintain that the video was authenticated. We did have the bar owner who viewed the video. The court viewed the video and said that it was an accurate depiction of the bar.
and the witness said it is from it's the camera that I've set up in my bar and I've reviewed it, and maybe it's not complete, but it is what it purports to be.
Exactly, and the trial judge was under the impression that we needed to bring in the experts from the police department that compiled or spliced the video. As you know, there's
I think because it's an issue of how the video was compiled and put together, I wanted to take a look and see what it was.
It would have been if we were able to get to trial, but I think that's why we're here, Your Honor. I think that, the judge sort of threw out our case based upon a motion in limine that, and that's why we're here. We were kind of stuck at that point.
And you are at your time, and if the panel has other questions.
Do have a question. You bring up an interesting issue with regard to evidence rule 901, with regard to the bar owner's testimony.
Right.
Is her testimony, would you say that in essence, she was saying that, it seems to me that she was authenticating that the video captured the bar.
Yeah, under the
Is
pictorial
that
theory.
sufficient? Because isn't the reliability that's being tested is whether the video is capturing the moment at issue?
Authentication is a very low threshold, Your Honor, and I do believe there's two theories, and I mentioned in my brief, and I think we met the pictorial theory of authentication, that she was able to testify.
Well, the
after viewing-
pictorial is when someone has already testified and says, yeah, this video
Exactly.
accurately represents what I saw. I think this is the silent witness
Mhm.
theory that we're applying here.
Yes, I see that argument too. I struggled with which one, would be applicable in this case. And the case we're able to go to trial, the prosecutor certainly was on notice of what the trial judge thought was needed to authenticate the video. And, we would have called that witness. In fact, the witness who compiled the video, the officer, was 30 minutes away and was on his way to or she was on her way to the courtroom to testify at this motion in limine, but the judge had lost patience at that point.
Which goes back to you could have started trial and called and maybe incurred the wrath of the judge, but at least gotten a definitive ruling. I know you believe you got a definitive ruling.
Yes, we did. I believe with, I know it on an appellate record, it's hard to capture some of the emotion in the courtroom and what was going on, but it was definitive. We would have been threatened with contempt, I think, if we tried to push it, but
And you are at your time. I'm not going to count against you. Are questioning, so you will have 3 minutes remaining.
Well, thank you very much, Your Honor.
Ms. Peters, you have 15 minutes. And I'd like to start, if I could, with the same question I asked Mr. Springman. Motion and limines are preliminary only and wait for the context of the trial, and you need to hear the evidence in the context before you make a ruling on it. What are we to do with that? How is this a final order?
Well, Your Honor, I think under the state's state versus Thote, which I would believe cited in both the state's brief and my brief, that this is a final appealable order. Because what happened, yes, normally a motion in limine is an anticipatory, and you normally have to wait until the trial begins, and the proponent of the evidence has to offer it.
Well, you can make a preliminary ruling prior to trial.
Correct.
And then confront it again when it's presented.
Correct. But the problem in this case is that the ruling was against the state. And I think this is where the Thote case comes in, is because it's against the state, so it's excluding their evidence, so it's weakening their case. As soon as they call that first witness, and that first witness is sworn, jeopardy is attached.
So then if the court stuck with its ruling, and the judge had been wrong on the merits of that ruling, the state would have no opportunity to present the evidence.
Correct. So especially if the defendant is acquitted because the evidence is kept out, there's no opportunity to review that. So I think that's why in the Thote case, which was based on, I can't remember the name of the Ohio Supreme Court case, but Thote is from this court, that they then treat motions in limine as the equivalent to a motion to suppress. And I disagree that the judge was making a definitive ruling right then and there, because afterwards, after the state asks for reconsideration on page 37 and the trial court denies the reconsideration of both motions in limine, the trial court asked, where do we go from here? This case was set for trial that day. The defense said, we're ready to proceed. The state was not. It wanted to appeal the rulings under Criminal Rule 12K. So I think this is a final appealable order under the basis that it would preclude the state from appealing it later.
And let me ask you a follow-up then on the merits of this 2E letter issue. How is that an evidentiary issue at all? What rule of evidence precludes that testimony?
I think it's under the basic competency, if there's a rule, 701, I think is the rule. Evidence Rule 701, because under the 28 CFR 16.22A, it's not just sanctions. It is a ban that says that no U.S. attorney or former employee of the department may testify unless they have this 2E letter.
And if they don't, what's the remedy? They get in big trouble, I assume. It's not to reverse a conviction of somebody where that evidence was offered.
Correct, but so the trial court would be in violation of federal law if it allowed the testimony without the 2E letter. So it seems implausible to ask the trial court.
If this was just like the former AUSA gets in trouble, then presumably like this wouldn't have really come to the judge's attention. Like, how did this all get before the judge?
It came before the judge because back in April of 2022, the state supplemented its discovery and named Zachary Kessler as a witness, but didn't actually indicate anything, nor did it, but it didn't supplement at the same time a document. What they wanted Mr. Kessler to testify to was his plea negotiations in the federal case. When Mr. Kessler was an assistant U.S. attorney, he negotiated a plea that arose from federal charges around the same incident. So he was trying to say that the plea and their negotiations, and he was going to testify about the court proceedings in federal court, about the plea document. That plea document, though, didn't get to the defense until May 19th, which was after the first trial date.
That makes my question. Was it Mr. Kessler or was the state saying like, I need this letter to testify, or we need this letter to have him
I believe because when the defense got the federal document, they finally realized what the scope of Mr. Kessler's testimony was going to be. So they filed a motion to quash initially. And so the trial court said, so on the morning of trial, there was this motion to quash and stuff. So it was raised, oh, hey, he's a former federal DOJ employee. He needs his TUI letter under 28 CFR 16.22. So I believe it was under the motion to quash, but then the trial court said, well, I don't think the motion to quash is the proper avenue here. You need to file a motion in limine. And at the same time, then the state was saying, we'll get the TUI letter. We can get it today. However, I disagree with Mr. Springman. I do not think the record definitively shows that there was a TUI letter.
Okay, so what if there wasn't? You said that the court would be in violation of federal law, but there's nothing that prohibits the court from allowing a witness to testify. The federal law prohibits the witness from testifying. So the witness would have to assert some privilege or something at trial.
But I don't think it would be appropriate for the court to allow the violation of federal law, because then there's not a competent witness to testify, because he's banned under federal law from testifying in this matter. So he's not a competent witness to testify.
Because federal law makes him incompetent?
Yeah, it's because there's a ban on his testimony. So, okay.
Was there an actual, I know the letter was what his testimony would have been, or I think Mr. Spring was indicating like he might have been able to testify even without the letter, but do we know exactly what that parameters of that?
On page 4, the prosecutor made a representation that the testimony would be about what happened in the courtroom and about the plea negotiations, about page 4 and 5 of the transcript of the May 25th transcript. So, and there was also a disagreement about what the plea document contained, about whether or not there was truly an admission, which is also wasn't disclosed in discovery until the 19th. So underlying all this is also discovery violations by the state, because they didn't provide this discovery until May 19th. And the discovery asking for witness statements or, written statements by the defendant was made back in 2020.
And there was some mention, pardon me if I'm wrong, but where the court indicated some concern about whether there was good faith.
Yes, that's correct. I believe that was more to deal with the video evidence because, again, the state, basically, yes, the trial court said, I think there's been some bad faith here because you're not even disclosing the name of the witnesses who are going to authenticate the video. And that's what's the purpose of the continuance that they got from the May 12th trial, was because they wanted to bring in a witness to authenticate this video. They did not indicate who and stuff. So we get there on May 25th and the defense tells the court immediately, they've not disclosed to us the witness. And you have the prosecutor at first indicating, oh, well, this witness was a non-disclosed witness. But then you have the defense counsel saying, I called you after the continuance. I asked you if this was a non-disclosed witness, and you told me no non-disclosed witness was going to testify. And the prosecutor admitted that was true. So we still have the state not disclosing who the authentication witness.
But that's not why it was excluded, though. I mean, that's
Correct.
all maybe
But it's all in the
100%
background.
true, but the reason it was excluded is because it wasn't authenticated.
Correct. And in order to be able to authenticate it, the witness has to be able to say, this is what it depicts to be. Miss Evans, the bar owner, couldn't do that because,
Why not? The bar owner says like, hey, that's my video camera.
but it's not just one video camera. It was 4 video cameras,
But all from her bar or from other locations?
all from her bar, but different aspects, single,
Why can't she say that
because
it's what it purports to be?
because she can say, yeah, that's a picture of my bar, but she can't say that the sequence that the video is played, that the snippets from each camera was in the right sequence, because she wasn't present. There was no representation that she could be a pictorial witness, like Judge Zayas pointed out. So she had to say, in order to be under the silent witness theory, she had to say, this video recording is done in the proper maintenance of my video equipment. However, when you combine 4 different videos, you can't say, she can't say that. She can't say, oh yes, this shot from the outside and this shot from the inside from camera 2, or this shot then
So
from.
why
three.
not wait till trial and have, if you think that there's a second witness necessary, probably, maybe, your argument, I assume, is both witnesses were necessary, because I know that you would argue at trial that the police officer couldn't authenticate the video because he just took it from the camera. So, but putting that aside, if both witnesses are necessary, on what basis could this have been excluded pre-trial?
Well, because this was an issue about whether or not they could present the video, and the state hadn't disclosed a witness. So we're
But
getting.
it wasn't based on the failure to disclose. It was based on authenticity.
Correct, but because the witness couldn't authenticate it. And we're here at the trial date. It's not like this was some pretrial hearing set a month in advance of trial.
But the witness is 30 minutes away. By the time you get through opening statements, the witness will be there.
But this is after the state was already told on May 12th, if you don't bring the witness to testify, there will be, the video won't be admitted. So the state had already gotten a continuance. The trial court actually, this trial will start to begin at I believe 9 a.m. and it was going till 12:30. The state or the trial court actually granted a continuance to allow Ms. Evans to return to the courtroom because the prosecutor had released her. So it wasn't like the trial court was acting irrationally or arbitrarily. It gave the state a chance, and the state should know this. The state should know that a compilation video can't just be the person testifying who, this is my video equipment. Yeah, my video equipment was seized by the state, but oh yeah, this isn't
But aren't those cross-examination questions that go to sufficiency of the evidence and not the authenticity of it? If she can say, yeah, those are my 4 cameras, yep, that's the view of those 4 cameras, then isn't it cross-examination? Well, you don't know what time those were. Do you know? I don't. You don't know what order this is. No, I don't. Why is that authenticity?
because the threshold is this what the proponent depicts it to be? Can someone say this is what the proponent depicts it to be?
And wasn't it, this purports to be the shot from cameras from my bar?
But it's not just shots of camera from my bar, it's the sequence. So she can't testify as to the sequence that the shots were put forward. So
Is it the sequence or isn't it we're going to reliability when we're talking about evidence rule 901. But isn't it with regard to the reliability of the video that was taken at the time of the incident?
I think reliability comes into it, yes, but it's also, someone has to be able to say, this is what it depicts it to be. Either because that person was there and present and saw the things as it played out, or because they say, oh, this is my video surveillance camera.
Most of the case law, you have someone testifying when you're talking about silent witness. You have someone testifying with regard to the system itself.
Correct.
This is how the system works. I was there when the police officer picked it up. I gave them the copy, and when I look at 901, I look at section 9, processor system, evidence describing a processor system used to produce a result and showing that the processor system produces an accurate result. So the question becomes, is there evidence that goes to that was provided?
There is not, because the system that processed the video that the state wanted to play wasn't from the Chalet Bar video. It was, as the trial court said, it was video of videos. It was produced by the Cincinnati Police Department with their equipment to say, oh yeah, well, when we splice this together, this was appropriately done. It did. It was not admitted. It could have been admitted during the authentication portion of the, as a exhibit to the hearing on the motion on the motion in limine about authentication, but it wasn't proffered. It wasn't admitted because there is references about the trial court seeing it. So that's how we know it's a compilation. Plus, we also had the witness testify that there was 4 different angles, and the first shot was from the outside, and then there was a shot on the inside. So we know that the individual videos were merged together into a single compilation video.
There's 2 arguments that are raised by the state. One has to do whether the whether the threshold is met. And the second one has to do whether the trial court treated this as if it was a permanent decision, and that it wouldn't revisit it at trial. Okay. So let's say for the first one, we say, yeah, it didn't meet the threshold. Okay. So now we're addressing whether it was whether it was a flexible decision, whether it was a final decision. When you look at the order, and certainly the language of the order seems to make it somewhat final, because the order says the motion to exclude the video evidence is hereby granted. And that's what the state complains of, that it was treated as a motion to suppress, as a motion to exclude. How would you address that?
I would say essentially it's the same as the motion in limine, that any evidentiary ruling done pre-trial is considered interlocutory. But in this case, because it was ruled against the state and then they said that they couldn't go forward, then it becomes the definitive version of it. So if the state had been willing to roll the dice and call the first witness, then yes, they would have had to proffer the video. They would have had to go through all the hoops. But the problem is for them is that they risked the trial court returning an acquittal.
And you are at your time.
Okay. So we simply ask that you affirm the trial court's decision. Thank you.
Thank you. Mr. Springman, you have 3 minutes remaining.
All right, thank you, Aaron.
Attorney Springman,
Thank you, Aaron. Yes.
if one were to argue that your argument with regard to the finality of the motions were premature, how would you address that?
That,
Do you understand what I'm asking?
in other words, that
Because
I
it
would-
never went to trial, because we don't know what the trial court would have done, that argument is premature at this point.
if our argument is premature, in other
With regard
words,
to authenticity, but just with regard to the argument of the finality of saying like, look, this was treated as a final decision and that the trial court would not have allowed for any further discussion.
then this would be a final order, and it means under the case law that it is a motion to suppress, even though it's entitled to, as a motion in limine, it was a motion to suppress. And then our argument would be is suppression would be improper because we're not dealing with constitutional issues, we're dealing with procedural violations. Because the TUI letter involves a procedural violation potentially. And that's complicated because Attorney Kessler said he could testify without that on certain areas, not all subject matter. And then second, obviously authenticity is a violation, would be a violation of Evidence Rule 901, which requires suppression because again, we're dealing with a procedural rule. We're not dealing with an issue of constitutional import. So the exclusionary rule would not apply. So it doesn't apply to non-constitutional violations. So that would be our argument.
Okay. Thank you.
Unless there are any other questions. All right, well, thank you for listening to our arguments.
Thank you.
All
Thank
right.
you both very much. This will conclude our arguments this morning for the First District Court of Appeals. We will stay on the bench because we're going to have a brief question and answer session. But if you would to close court, just as an official matter.